Okay. Good afternoon, ladies and gentlemen. How do you manage on first step of this term? In the coming months, we should be perhaps busy with the hodgepodge of presidential campaign. Do you support Mr. An for the next presidency? How do you perceive his long hesitation to announce running office? Among the three hopefuls, who do you prefer most? Have you taken time to read each of candidates' political promise? Anyway, we must be exciting to celebrate a Chuseok, national holidays for full moon and harvest. I'd like to defer the next class for other occasions that a number of students seem to travel for their hometown on next Tuesday. Have you got it? The makeup class would be made on the notice board of college for the time and place. Our final topic on the Constitution of Commonwealth countries would be about the freedom of expression. Of course, we briefly referred to survey the state action theory about its historical development and the typical cases, including the essence and the implications of the court rules. We have a state action in the 19th century, introduced on page 200. In general, both the 14th and 15th Amendments indicate the only state action that violates the amendments is prohibited. The early cases held that these amendments, therefore, did not apply to private acts of discrimination, that individuals were free to discriminate if they chose to do so. But the state action in 20th century would a little differ in terms of a public function analysis and the nexus approach. In Marsh versus Alabama, decided in 1946, a private corporation owned a town and posted a sign prohibiting peddlers. Appellant distributed religious literature on the streets of the company town and was convicted of violating a state trespass law that made a crime to enter or remain on the premises of another after being warned not to do so. The conviction was reversed because the town streets, although private owned, were in effect a public place. The court held that neither the state nor any private owner can totally ban freedom of expression in public places. Nor can a state trespass law be applied to enforce such a plan. Ownership does not always mean absolute dominion. The more an owner opens up his property for use by the public in general, the more these rights become circumscribed by the statutory and constitutional rights of those who use it. In other words, this case shows that state action includes not only any action taken directly by the state executive, legislative, or judicial branches, but also any such action taken indirectly by delegating public functions to private organizations by controlling, forming, or to some extent becoming involved in the private action. One other case involved a shopping center. How about shopping center? The court has since held that the company town rationale does not extend to the pathways in a private-owned shopping center. In 1962, the case called Evans versus Newton dealt with the situation involving parks. In that case, the court held that a park which had been created pursuant to trust could not be operated on a racially restricted basis as required by one of the trust provisions, even if the city, the original trustee, no longer operated it. In so ruling, the court stated that although there was a private trustee, the operation of the park on a racially restricted basis violated the 14th Amendment because the city still provided maintenance and the service rendered by the park is municipal in nature. Later in Evans versus Aveny of 1970, the court upheld the state court's termination of the trust creating the park because the decedent's intention that the park be operated for whites only was impossible to fulfill. The court held that the reverter to the heirs violated no federal rights since the state court decision to eliminate the park impacted equally on both blacks and white citizens. But this position was limited in Jackson versus Metropolitan Edison, decided in 1974. And also, that limitation was confirmed in a Flagg Brothers versus Brooks, which dealt with the commercial rights and remedies. In Flagg Brothers versus Brooks, Brooks was evicted and her possessions stored by Flagg Brothers, was a defendant in this case. When P failed to pay storage charges, they threatened to sell P's possessions pursuant to procedures established by the New York Uniform Commercial Code. P brought an action seeking damages, an injunction, and declaratory relief that the UCC provision was unconstitutional. The district court dismissed the complaint, but the Court of Appeals reversed, finding state involvement in this action sufficient to invoke constitutional protections. The issue to be if a warehouseman's set of goods entrusted to him for storage constitutes state action because permitted by state law. The court said no. The lower court judgment was reversed. According to the court opinion, P claims that the state delegated to D a power traditionally exclusively reserved to the states, while many functions have been traditionally performed by governments, very few have been exclusively reserved to the state. The settlement of disputes between debtors and creditors is not traditionally an exclusive public function, so this action is not state action under this test. He also claims that this action is state action because the state has authorized and encouraged it by enacting the UCC. While private action compelled by a state is properly attributable to the state, more acquiescence by the state is insufficient. The state has merely refused to provide a remedy for this private deprivation of property. Therefore, this action is not a state action. We have a dissenting opinion. Dissenting opinion focused on the question whether a state statute authorizes a private party to deprive a person of his property without his consent must satisfy due process requirements. Clearly it should. Permitting only state delegation of exclusive sovereign functions to bring private action within constitutional bounds is inconsistent with prior decisions. It should be permitted to challenge the state procedure permitted by a state law. What about the case involving conduct of elections? Since the conduct of elections is an exclusively public function, the court has consistently invalidated a state attempts to vest in private boards or political parties any effective control over the selection of candidates of the exercise of voting right, as by giving authority to a political party to determine who can vote in primary election from which the party nominee for the general election is chosen, as by structuring the state's electoral apparatus to vest in political party the power to hold a primary from which blacks are excluded, or to determine who shall run in the party primary in which blacks are permitted to participate. Look at the case Terry vs. Adams, decided in 1953, and also Smith versus Allwright, decided in 1944. We now see a nexus analysis. Evolved in the case Shirley versus Kramer, decided in 1948. In this case, Shirley, a black male, purchased residential property. The unknown to D was encumbered by a restrictive agreement that prevented ownership or occupancy of the property by non-Caucasians. Kramer was plaintiff in this case, a neighbor and owner of other property subject to the restriction, brought suit to restrain D from possessing the property and to divest title out of defendant. The trial court denied the relief, but the Missouri Supreme Court reversed and defendant appealed. Therefore, the court is faced with the issue if the 14th Amendment Equal Protection Clause prohibits judicial enforcement by state courts of restrict covenants based on race or color. The court said yes. The lower court judgment reversed. Property rights are clearly among those civil rights protected from discriminatory state action by the 14th Amendment, according to the court opinion. Early decisions invalidated any government restrictions on residence based on race. Here, the restrictions are purely private and standing alone are not precluded by the 14th Amendment. However, actions of state courts intervened. Actions of state courts are state actions within the meaning of the 14th Amendment. Judicial enforcement of these private racial restrictions constitutes state discrimination, contrary to the 14th Amendment, and denies the equal protection. This is a very important case to concern the judicial involvement, the form of a intervention as a pertinent to the state action in terms of a constitutional purpose. In this line of nexus analysis, we have many of the additional cases, which would be Pennsylvania versus a Board of Trust decided in 1957, and Barrows versus Jackson decided in 1953, and also Bell versus Maryland decided in 1964. In Burton versus Wilmington Parking Authority decided in 1961, leasing of public property has been raised if it could be classed as one form of a state action. To say a lessee of state property whose lease is for the state interest and which form an integral part of state operation are required to comply with the 14th Amendment. The court held affirmatively. And one other case involves a public use by private groups. Named Gilmore versus Montgomery, decided in 1974. Later, in the case titled Musology versus Irvis of 1972, the court applied a significant extent analysis. In that case, Irvis, a black, was refused service by Musrich, who was defendant in the case. He claimed that this refusal was a state action because he was licensed by a state liquor board to sell alcoholic beverages. A three-judge district court held for P on the merits. A defendant appealed. In this case, the court held the state alcoholic license of a private club does not constitute state action to require that the club observe a 14th Amendment prohibitions against discrimination. And in CVS versus Democratic National Committee, the broadcast license was disputed if it pertains to a state action theory. A case sustaining the FCC's refusal to compel broadcasters to accept editorial advertisement, three of the justices also concluded that the action of the licensee was not governmental action for purposes of the First Amendment, since the FCC had not fostered the policy and thus was not a partner to the action and did not profit from it. And in Reitman versus Murky, the court held a state constitutional provision demand a state neutrality in private residential discrimination matters denies a due process. Just neutrality could be subject to a constitutional must. The concurring opinion from Justice Douglas said real estate brokerage is state licensed and regulated and must be decided to a non-discriminatory service. Also, we have dissenting opinions from Justice Haran, Bragg, Clark, and Stewart. State action exists whenever a state has affirmatively facilitated, encouraged, or authorized acts of discrimination by its citizens. States are not required to outlaw discrimination, but they cannot do anything to encourage it. That position was ascertained in Jackson versus Metropolitan Edison Company and Frank Brothers versus Brooks. Those cases rejected both the public function argument and the assertion that the state's authorization of the activity made the activity attributable to the state. And quote further on this path of developments in Blum versus Yersky, decided in 1982. It involved the transfer of nursing home patients from private-owned but publicly subsidized nursing homes to lower-cost facilities. As a result, the patients' Medicaid benefits were reduced. The court held that because the decisions were made by private physicians, no state action was involved and no violation of procedural due process had occurred. And in Randall Baker versus Cohn, the court held that a decision to fire a teacher made by a small private school that was publicly subsidized and regulated was not state action. However, in Lugar versus Edmondson, the court upheld damages under Section 1983 for conduct down on the color of state law when the creditor had attached the debtor's property in ex parte proceeding. The court held that this was state action because the writ was issued and executed by state officials. Therefore, you need to be careful whether the state power intervened to the cases of a private nature. A promulgation of rules adopted by a state university. In NCAA versus Tankania, decided in 1988, the court held that a public university's disciplinary action against its employee taken in response to encouragement by the NCAA, a private organization, would not render the NCAA's action a state action. The court noted that the NCAA and the university were adversaries, not partners, and that the university's adoption of NCAA standards did not mean the NCAA acted under the color of state law in establishing those standards. It is a private organization. But how about, for example, a National Academy of Sciences or National Science Foundation? And we also need to be careful about the nature of the organization. Is it a federal agency or a state organization or other forms of a public nature or that of a private one? And we may see a failure to act, which means a negative of active or positive state involvement. A state agency's failure to intervene and take custody of a minor after receiving reports of child abuse did not constitute actionable state action, because the due process clause does not require the government to protect the life, liberty, and property of its citizens against invasion by private actors. And the case was furthered on a congressional power to reach a private interferences with constitutional rights. That issue involved a criminal sanctions. A private action without state action, raised in the case United States versus Guest, decided in 1966. And other forms of state involvement to a private interference, where a private individuals willfully engage in a joint activity with a state officials to infringe the civil rights of others. The private individuals as well as the state officers are subject to sanctions under federal law, which federal law has been passed pursuant to the enabling provisions of the 14th Amendment. That kind of cases, in line with the criminal sanctions, would be Screw versus United States, decided in 1945, and Williams versus United States, decided in 1951. And in Griffin versus Branquist of 1971, touched on the civil sanctions. Griffin was plaintiff in this case, and other blacks were riding in a car which a Branquist was defendant in the case, and other whites stopped. He then assaulted P. P sued for damages under 42 U.S. Section 1985 is sued. But the lower federal court held the Section 1985 third applied only to conspiracies in the color of state law. P appeals. In this case, the court affirmed the Congress has power to punish private conspiratorial action intended to deprive a member of a minority group of his equal rights. This line of cases bears significance in the context of a Civil Rights Act. And there would be cases dealing with the private conduct under the 13th Amendment. Private sales was disputed in the case Jones versus Alfredo Maye, decided in 1968. And also, admission to private schools was disputed in the court law. The case was titled Runyon versus Megley, decided in 1976. Then we now face with the question. It is very basic in terms of a constitutional theory. That is Congress limited to remedying what the court finds unconstitutional, or made remedy what it itself deemed unconstitutional. In other words, we need to consider whether Section 5 of the 14th Amendment confers remedial or substantive powers. The right to vote for federal, state, and local officials is protected from both state and federal government infringement by the provision of the 15th and 19th Amendment, as well as from state infringement of this right by the due process, equal protection, and privilege and immunities clauses for the 14th Amendment. Also note that the 24th Amendment protects the right to vote, but only in federal elections and only from intrusions on this right imposed by poll or other taxes imposed by either state or federal governments. The state may impose a literal test in the context of the election. In Lester versus Northampton County Board of Elections, which is the case in 1959, the Supreme Court upheld a North Carolina law that required a non-discriminatory reapplied literal test in order to register to vote. In the Voting Right of 1965, Congress has the power by the enabling clauses of the 14th and 15th Amendment to pass legislation to enforce the provisions of these amendments. In 1965, Congress passed the Voting Rights Act, which essentially created a rebuttable presumption that literal tests in certain states were used to perpetrate racial discrimination. Those are a line of cases would be a South Carolina versus a Kunzenberg, and also Oregon versus Mitchell, decided in 1970. The latter case was concerned about the Voting Rights Act amendments of 1970. And the rest of the pages will be reserved for your further review. And we turn to the freedom of expression issue. The First Amendment of the United States Constitution guaranteed a freedom of expression to say the right to free speech and about the press and the freedom of association are fundamentally cherished in the democratic Constitution. Why is this so? That is principally because the Republican form of government, even for the Constitution itself, could be created, sustained, developed, essentially depending upon the shared value, intelligence, and conviction, and so forth, which assumed to be formed on the basis of free flow of ideas. You may draw upon some of extremes. The democratic representation could fail due to suppression of ideas, communication, or useful information. Can you feel that the Fifth Republic may be unabateable, provided if the publicity of 1980's Gwangju incident were to be made public to the fullest extent? Can the North Korean governor survive if the freedom of press were to be secured? Why do we illustrate Chinese Emperor Qin's burning of scholars' books as one of the greatest evils in the world history? These turmoils were the situation that the newborn United States faced. The British Act at the time normally utilized a prior restraint system to select or quell the expression of a potential dislikes, potential opposers. Would it be permissible when we envisage our basic laws and democratic representation? If we are liberal and equal creature under the God or divine law, the ideas have to flow freely, but only subject to market competition. Those ideas, of course, could be finally concerned about the formation of our government. And the freedom of expression also serves a change of regime, shift of governmental power, and even plays a presumptive role for the transformation of Constitution itself. Let us see the other important aspect in which the freedom of expression can play a critical role. It is conceived that the free speech, freedom of press, and right to association serve to shape the humanity as an intrinsic creature as God guides. It is critical to develop a human ego intellectually and emotionally. The esteem of humanitarian value and the concept of his inalienable rights are the grounded a starting point that the modern democrats have fought against their perceived evils. The UN document, the constitutions of most democratic countries, confirmed this assumption. The freedom of expression operates to that sublime end. We now briefly explore the constitutional history and the trends of a U.S. court of a selected scope of cases. As you'd be aware later on progress, the court holdings would vary to respond to the court of times. For example, the clear and present danger rule would not be absolute on the later cases. A particular attention needs to be given to that important distinction between the content-neutral versus content-based regulation. You can be easy that the content-based regulation would be more suspicious in the constitutional review other than the former. It is, in nature, more susceptible to evils of suppressing the ideas. For the content-based regulation, the frequent subject debated in the court would be on political speech, obscenity, commercial speech, symbolic expression, fighting words, hate speech, damage to reputation, and privacy. I've chosen some of cases to introduce you to this area of U.S. law, which could be available in the printout. I expect you can retrieve in later of this class. Let's have the First Amendment language. It states, Congress shall make no law, blah, 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 abridging the freedom of speech or of the press, of the right of the people peacefully to assemble and to petition the government for redress of grievances. The right to freedom of expression is not an absolute right to say or do anything that one desires. Rather, the interests of the government in regulating such expression must be balanced against the very strong interest on which the right is based. As I've introduced, the rationale behind freedom of speech is that such freedom will lead to the discovery of truth and better ideas through the competition of differing viewpoints. And such speech and action is a necessity for free society that is to be governed by democratic principles. Legislation normally enjoys the presumption of validity. Legislation that imposes limitations on freedom of expression is presumed valid until the person attacking such legislation can show otherwise. The First Amendment right is paramount, one of paramounts in terms of a constitutional context, but still the legislation enjoys a presumption of validity as other areas of law. Note that sometimes the Supreme Court will hold that the statute is invalid on its face. In other cases, and far more frequently, the Supreme Court will hold the statute is unconstitutional only as applied to particular fact situation. There has been considerable debate over the years about whether First Amendment rights have a preferred position or whether restraints on freedom of expression are reviewed with special care. Most justices agree that the First Amendment rights are special. The issue concerns how or in what way this specialness is implemented. To say that restrictions on the First Amendment rights receive special scrutiny may be saying that they are presumptively unconstitutional, or the justices in this area have wide latitude for enforcing their own prejudices, and certainly this should not be true. We now briefly explore the Schenck versus United States, which could be a properly labeled as a political speech consideration. The Espionage Act of 1917 made it a crime to attempt to cause insubordination in the military forces or to obstruct recruitment. Schenck were charged with such an attempt as a result of publishing a pamphlet that attacked the Conscription Act and encouraged a disobedience to it. A defendant, a Schenck in this case, appeals to conviction under the Act. Then, may Congress outlaw a speech that presents a clear and present danger to an important government interest? The court agreed to congressional action. The right of free expression is not absolute, but varies with the circumstances. A man is not free to force yell fire in a crowded theater. The first question is whether Congress is pursuing a proper end or purpose in the legislation. Here it is. Congress has the right to prohibit the evils at which this statute is aimed, especially in time of war. This case was presented to court review in the year of 1919. In that time, the United States was engaged in the World War I. The next question is, to what extent Congress can go in seeking to effectuate its purpose? That is, how far can it go before it is prohibited by the First Amendment? Congress cannot make speech a crime unless there is a clear and present danger of action resulting from defendant's words that would lead to the legitimately prescribed evil. The court in Schenck also seemed to set up some sort of a scale concerning types of speech. At one end, receiving a low degree of a judicial protection, a speech that is highly emotional, commands that do not appeal to reason or logic, but have the effect of force and advocacy of action. At the other end, receiving a high degree of protection, a speech that has a high degree of ideological content. It is matter, of course, that in the clear and present danger rule, the action would be posing more danger than the expression purely containing an ideological content. In 1919, the court decided Ford versus United States. And in 1991, that versus United States was subject to court review, which is a case involving a public speech. And in case titled Message Publishing Company versus Patton, the expression of a nature involving incitement was decided. In that case, the court held the government may not refuse to permit use of the mills by private magazines to criticize a public policy. The decision by Judge Learned Hand was reversed on appeal. The circuit court did not agree with the incitement test and deferred to the Postmaster General's discretion. Many of cases in line with the political speech are present in the post-World War situation. For example, Gittel versus New York, decided in 1921, said states may prohibit advocacy of criminal anarchy when there is no concrete reason or likelihood of such a result flowing from such advocacy. Justice Holmes dissented that these words did not constitute the present danger of an actual attempt to overthrow the government. They were too indefinite and ineffective. To say these words were an incitement proves nothing, for every idea is an incitement and may move the recipient to action depending on outside circumstances. The court in case Whitney versus California devised the rationale for free speech. In the Whitney Code confirmed the state may outlaw a mere membership in a criminal organization, even when the individual member intends no criminal acts. And where the clear and present danger test was an issue, there will be some problem about a rule of evidence. The following evidence would be relevant. Evidence of any actual effect from the speech. The type of language used. Advocacy of action, for example. The circumstances in which the words were spoken. And the intent of the speaker. The famous Smith Act, enacted in 18 U.S.C. 2385, makes it unlawful for any person to knowingly or willfully advocate, abet, advise, or teach the duty, necessity, desirability, or priority of overthrowing any government in the United States by force or violence, or to attempt to commit or to conspire to commit any of such acts, or to become a member of any organization advocating such acts, knowing its purposes. Then in Dennis versus United States, the court should answer if Congress may pass a law forbidding association with organizations advocating overthrow of the government. The court said affirmatively, and the lower court judgment was affirmed. However, mere advocacy is insufficient to suppress. In Yates versus United States, decided in 1950-A7, that the court held the Smith Act does not reach persons conspiring to advocate mere belief in the desirability of overthrowing the government. The court has consistently recognized the distinction between advocacy of abstract doctrine and advocacy directed at prompting unlawful action. The trial court misunderstood the Dennis case to obliterate that distinction. The distinction is not between advocacy as such and mere discussion or exposition of violent overthrow as an abstract theory, but rather between advocacy of action and advocacy of belief. Therefore, the Smith Act does not prohibit mere advocacy or teaching a forcible overthrow as an abstract principle, apart from an effort to instigate action to that end. This is true even though such advocacy is engaged in with evil intent and uttered with the hope that it may ultimately lead to violent revolution. The urging of action for forcible overthrow is a necessary element of the proscribed advocacy. How about adequacy of proof? That issue was a dispute in Scales versus United States, decided in 1961. And the case has frequented the area of anti-communist laws of the 50s. For example, the restoration requirement sustained in the case titled Communist Party versus Subversive Activities Control Act, decided in 1961. In the case, the restoration requirements were sustained against the text as a bill of attainder. The court also applied a balancing test to determine whether freedom of expression had been violated. And the court considered the object of the statute, the means, and its effect when dealing with this area of laws. But in Alberton versus Subversive Activity Control Board, restoration order was reversed. The court held that both orders directing petitioners to register as party members violated the privilege against self-incrimination. In After versus Secretary of State, decided in 1964, the passport laws was disputed around the communist organization. Section 6 of the Subversive Activity Control Board was finally found unconstitutional. The law criminalized the issuance of passports to members of organizations required to register as communist organizations. The court found the law too broad. It applied to persons who were not aware that they were members of the organization required to register and was independent of the degree of their activity in such organizations and was unrelated to the purposes or the area of their travel. However, the dissent argued that the statute was constitutional as applied here, since the defendants were high-ranking officials of the Communist Party. And the congressional action may impose some employment restrictions in the context of a anti-communist program. In the United States versus Rovell, the court found that the related provision of the Smith Act was unconstitutional. The law was an abridgment of freedom of association, since it applied to all individuals in such organizations, even though they might be unaware of the organization's unlawful aims or may disagree with them. You can find modern applications surrounding a subversive activity. In case Brandenburg versus Ohio, decided in 1969. And there was a time period in the United States about an anti-war protest. Which is the matter with a Vietnam War in the context of many of the national values and a strategy. Most political activities by government employees may be reasonably curtailed. However, this is not true with respect to freedom of political expression. So, for example, the Supreme Court held in Bond versus Froh, decided in 1966, that a state legislature could not refuse to seat a duly elected representative on the basis of his speeches critical of Vietnam War policy and selective service system. And the court would normally offer a rather reduced protection for certain contents. That class of expression would be a fighting words, a damage to reputation and privacy. It might be a obscenity, obscene expression. In Chaplinsky versus New Hampshire, decided in 1942, the court held the state may forbid the use of words in a public place that would be likely to cause an address to fight, so-called fighting words. Chaplinsky had called the city marshal a damned fascist and a goddamn racketeer. The court held the fighting words are one of the well-defined and narrow limited classes of speech, not protected by the Constitution. Other classes include a bribery, perjury, and criminal solicitation. Libellous speech is in somewhat the same category as obscenity. It receives little constitutional protection. However, the same difficult questions exist here also. That is, what is libellous and What tests are to be used to distinguish protected from unprotected speech? You can find the court holdings about group level. In the case Bull-Horians versus Illinois, decided in 1952. In that case, the court held a group libel may be made per se illegal, even without the showing of a clear and a present danger. This situation might assimilate with the Yong-suk Kang's case in South Korea. Later, you can see the picture portraying the late Jin-suk Choi and Yong-suk Kang. Oops. And one other notorious case around this area of law would be a New York Times company for Sullivan, decided in 1964. The case involves the libel statement against the public officials. Sullivan was a commissioner of the city of Montgomery, Alabama, and supervised the police department. The New York Times was defendant in this case, carried a full-page advertisement that included several false charges or repressive police conduct in Montgomery. P sued for damages on grounds that de-libelled him, although P's name was not mentioned. Although the P's name was not mentioned, the accusations of the ad could be read as referring to him. Many of readers could easily notice that the object would be against a defendant. The trial court awarded damages of $500,000, which were upheld in the state court. The controlling state rule of law dealt with libel per se, established here by merely showing that their statements reflected upon the agents P supervised. Once libel per se is demonstrated, the only defense is truth. A defendant appeals. The court held the First and 14th Amendment prohibits state rules to allow a public official to recover damages for a defamatory falsehood relating to his official conduct without proof of actual malice. And the court later developed a public figure doctrine. The Supreme Court has stated the same privilege to make statements about a public officials exists for statements made about a public figures. In Curtis, a publishing company versus a bus, decided in 1967, Wally Bus, the former director of athletics at the University of Georgia, had sued after he was reported to have thrown a football game while at the university. In Associated Press versus Worker, the court held the general worker, a retired Army general, was a public figure. However, a person is not a public figure simply because she is extremely wealthy and engaged in divorce proceedings of interest to the reading public. The fact that she files for divorce does not mean that she voluntarily chooses to publicize her married life, since going to court is the only way she can legally dissolve her marriage. You can see this gist of a court opinion in the case a Time versus Firestone, decided in 1976. And the court also rendered some opinions about private individuals. Therefore, it is very significant how to class the damaged a person in terms of a core logic. For example, the chancellor chair be considered as a public figure in line of in this standard, appears through the line of cases. And in Gertz versus Robert Wells, decided in 1974, a member of the press who published defamatory falsehood about a person who is neither a public official nor a public figure, but who is involved in public issue, may not claim a constitutional privilege against liability for injuries. And in Dunn versus Bradstreet, Dunn and Bradstreet Incorporation versus Grimmo's Builders, decided in 1984, the court dealt with an elimination of media non-media distinction issue. The court held a defamed person may recover a presumed and punitive damages, even without proving actual malice, if the defamation is not speech on a public matter. Most of cases in this line would be labeled as a constitutional tort. And the constitutional document offers one of a standard to apply to the cases of a civil law nature. It is so there is a great implication in the context of a public and private law distinction. And in case Hustler Magazine versus Forward, decided in 1988, a public figure may not recover damages for emotional harm caused by the publication of an offensive parody intended to inflict emotional injury, but that could not reasonably have been interpreted as stating actual facts. The Supreme Court has held the matters of public interest may be commented on, say from an action for invasion of privacy, unless the plaintiff can show that the person making the publication was motivated by actual malice. For example, in Times versus Hill, the Supreme Court reversed the lower court judgment for damages for invasion of privacy that had been based on a magazine article about a Broadway play. The article alleged that the plot of the play was based on the actual experiences that the plaintiff and his family suffered at the hands of some escaped convicts. And in Ross versus United States and Alvarez versus California, decided in 1955, the court defined the term obscenity in terms of a constitutional application. Ross, defendant, was convicted of mailing obscene materials in violation of a federal obscenity statute. Alvarez, who was defendant, was convicted of similar state offense. Defendants appeal their convictions. Then, is obscenity judged by the prior standard outside the protection of the First Amendment. If it considered to fall within the definition of obscenity, the code does not protect the expression from the constitutional ground. We could find a post-Ross decision in Kingsley International Picture Corporation versus Reason, decided in 1959, and also Stanley versus Georgia, decided in 1969. The court changes its prior position in United States versus Ryder, decided in 1971. The court reversed the lower court's dismissal of an indictment under the federal law prohibiting the mailing of obscene materials. The court rejected the lower court's contention based upon the ruling in Stanley that if a person has a right to possess obscene material, then a person also has a right to deliver it. The court held that the incitement was not an infringement of the right to freedom of mind and freedom of mind and soul, or of the right to privacy in one's home. The court framed a modern standard for defining obscene materials in the case titled Miller versus California. Obscenity is now within the area of a constitutionally protected speech or press. Ross versus United States presumed obscenity to be utterly without redeeming a social value, but the Memorial case transformed the presumption into a necessary element of proof. Memorial thus requires a prosecution to prove a negative, and that test cannot be upheld. Regulation of obscene material is restricted to works that depict or describe sexual conduct and must specifically define the conduct. The basic guidelines for the trial of fact must be, let's have the elements offered by the Miller Court. First, whether the average person applying contemporary community standards would find that the work, taken as a whole, appeals to the prurient interest. Second, whether the work depicts or describes in a patently offensive way sexual conduct, specifically defined by the applicable state law. And third, whether the work taken as a whole lacks a serious literary, artistic, political, or scientific value. Thus, material can be regulated without a showing that it is utterly without redeeming a social value. We have two dissenting opinions from Douglas M. Brennan, A. Stewart, A. Marshall. In Paris, Adult Theater 1 versus Slater, decided in 1975, confirmed a permissible extent of a state regulation about obscene materials. In this case, the court sustained the rule that a state may prohibit a commercial exhibition of obscene films to consenting adults. And in New York versus Ferber, a child pornography was disputed in a court whether it could be properly regulated as a in the constitutional, in a public interest. The court said a state may prohibit distribution of all child pornography, even without requiring that it be legally obscene. And also, the pornography raised a problem in the context of a feminism. In American Booksellers Association versus Hurnett, decided in 1985 and 1986, a federal district court held that a city may not enact an ordinance prohibiting pornography on the theory that it discriminates against women. The interest in preventing sex discrimination does not outweigh the free speech interest. The court concluded that acceptance of the civil rights approach could lead to prohibition of any speech the legislature finds unfair to a particular group. And you can find in the printout later in the class the summary of discussion covering a hate speech and offensiveness and less variable speech. And might be available about the commercial speech. As you may be aware, the commercial speech would be less weighty against the other forms of a political speech. Therefore, the legislature may have a wider leeway to regulate a commercial speech. In some case, symbolic expression will be disputed in court. United States versus O'Brien would concern a draft card burning and raise a freedom of expression issue. But the mode of expression is not a verbal, it's just a symbolic. But contains some content in terms of a dichotomy developed by the core theory. And the expression classed as a content neutral would be regulated by the theory titled a time, place, and manner restriction. The court defined the elements relating with the time, place, and manner restriction doctrine. Okay, that will be end of cases in the printout. I now surmise that you may be curious about the Korean struggle in the context of this critical issue. That will be the task for the course of a constitutional law in this college. But I would like to brief on the operation of legal rules on the framed version. You may be usually faced with the articles of newspaper or report of media that a forms of expression, including a statement, command, revelation, misappropriation of others' photo, and others, intrudes the privacy of a popularities, certain groups or other individuals. One of the former congressmen, Yong-Suk Kang, was once subject to public criticism for his a defamatory statement about the media personnel. It could be demeaning the group of TV announcers to say that they have to give all of us to get a job position. What are the verbal abuses on the internet for concern? The late Jinshi Chair, I showed two photos to represent a Korean story in the previous context. The late Jinshi Chair and his brother was probably the worst case, scapegoated by the explorers of the internet. In theory, this kind of problem would be classed as the sector of a constitutional tort. We reviewed the line of cases in this context that normally involves the intrusion of privacy and libel or defamation. It is also considerate to distinguish between the civil law concepts of tort and constitutional values from the freedom of expression. That area has a potential to throw light of effects on that kind of problem. Of course, the public aspect of constitutional review would probably be tasked with the responsibility of an independent constitutional court in the Korean context. The cases reviewed in this class would normally charge on that court, other than ordinary Supreme Court in South Korea. The forms of review are expressly provided in the Constitution and the Judicial Act of a Korean Constitutional Court, which could be distinct from the U.S. system. As the purpose of this class is intended on the basics of a U.S. constitutional law, it would be better to discuss one of hypothetical case, which I suppose offer a paradigmatic problem. I titled Exercise of Your Basics, hypothetical question on the constitutional law. It shows a fact pattern concerning some of typical constitutional problems raised in United States court. State law makes it a felony to either promote a dogfight or knowingly attend a dogfight where admission is charged. Ruth, a reporter for the Dispatch, city's only newspaper, observed the state's dogfight by posing as a patron and paying the admission fee. She took over 30 photographs of the event with a concealed camera. Later, she wrote an article about the event in Dispatch that did not identify anyone else present, but it was accompanied by one of a photograph showing two dogs in bloody mortal combat. So the reporter was involved in some of a project activity for his business, and later he was called to the criminal procedure before the grand jury. And this, his form, dispatch, was torn against the request from the state authority. That kind of dilemma was brought to the court proceedings about the constitutional issue covering freedom of expression and equal protection and other Fifth Amendment issues. Law professor might give you two set of questions. To grade your exam papers, to grade your answer sheet. Let's see, in the first question, the professor may ask, what arguments based on rights guaranteed by the U.S. Constitution could Luz reasonably make in support of action for an order questioning the grand jury subpoena, and how should the court rule on each? And in the second question, the professor may inquire, what arguments could the dispatch originally make in support of his claim that the city ordinance violates rights guaranteed under the U.S. Constitution? And how should the court rule on each? In this case, the city ordinance banned the coin-operated news racks managed by a dispatch in retaliation of a opposing position of a dispatch. Dispatch failed to respond to the request of a state authority, in this case, the city council. On its face, we may be suspicious if the city council has a kind of intention to specifically address the dispatch. Then how can you respond to these two sets of questions raised by a law professor? Let's see the sample answer about the first question. Luz may request to quash the grand jury subpoena. His theory might be grounded on the Fifth Amendment privilege not to testify. The Fifth Amendment prohibits the government from compelling self-incriminating testimony. The Fifth Amendment prohibition against compelled self-incrimination is applicable to the states through the 14th Amendment. Here, Luz is being called to testify before the grand jury and is being asked to answer questions about the illegal dogfight she attended. Is a female reporter for Dispatch. It is really striking to see the mortal combat of dogs. It may shock the conscience of public that the state now made it one of felony in the criminal purpose. This kind of a context could be conformed in the given a fact situation. I have not perfect through the fact situation, but you may later be debatable about that. And Ruth paid an admission fee to attend the dogfight. Ruth may properly assert a Fifth Amendment privilege and refuse to testify unless she is granted use or transactional immunity. You need to know that the Fifth Amendment applies to the grand jury proceedings. However, a person served with a subpoena requiring the production of documents tending to incriminate her generally has no basis in the privilege to refuse to comply. This is because the act of producing the documents does not involve testimonial self-incrimination. The shield of a Fifth Amendment privilege is just confined to the testimonial context. Production of documents would not fall within the Fifth Amendment privilege. Thus, forcing Ruth to produce the photograph in response to the grand jury does not violate the Fifth Amendment right. Ruth may raise a First Amendment right to justify his claim in this case. Ruth claimed that forcing her to testify before the grand jury violates the First Amendment freedom of speech and press will be rejected. The claim would not be successful. The Supreme Court has long held that requiring a journalist to appear and testify before a state or federal grand juries does not abridge a freedom of speech or press. This is true despite the claim that such a requirement deters the flow of news from confidential sources. Moreover, the court has refused to create a conditional privilege not to reveal confidential sources to grand jury conducting a good faith inquiry. In conclusion, the court should deny Ruth's request to quash the subpoena to produce the unpublished photographs. The photographs were pictured during her attendance in a dogfighting. And the court, however, should allow her to assert her a Fifth Amendment right not to answer questions concerning the illegal dogfight unless Ruth is granted immunity from a prosecution. And we have other party called dispatch. Dispatch may claim that the city ordinance is unconstitutional. That claim would be grounded on the First Amendment right. Dispatch will argue the city's ordinance violates its First Amendment right to free speech. A law which seeks to regulate speech is presumptively unconstitutional. To justify content-based regulation of speech, the government must show that the ordinance is necessary to serve a compelling state interest and is narrowly drawn to achieve that end. City Council enacted an ordinance banning all coin-operated news racks from city's public sidewalks and any other public property to improve public safety. On its face, the ordinance does not regulate the content of speech because it does not in any way interfere with the content of a dispatched publication. Thus, the ordinance is a content neutral. If the ordinance is considered content neutral, we may find the core rules to apply to that class of case. Content neutral speech regulations are subject to intermediate scrutiny and will be upheld if the government can show that they advance important interests unrelated to the suppression of speech, and if they do not burden substantially more speech than necessary to further those interests. Dispatch will prevail on both fronts. City Council's passing of the ordinance was a direct response to Luce's refusal to cooperate with the police investigation of the dogfight. The action followed remarks by several council members who stated that the dispatch was guilty of a bad citizenship. This context was expressed in the given fact. This shows that the City Council acted not to advance an important interest, but to punish dispatch for supporting a loose decision to advance an important interest, but to punish dispatch for supporting Luce's decision to refuse the police request. There are other media in this locality, in this hypothetical locality, and this passage is a major disputing a media of through the all coin opera news racks. Upon response of a disfavored position from a dispatch, the City Council enacted an ordinance to abolish all coin opera news racks in certain places. The stated end of that ordinance is to improve public safety. But let's have time to think about it. All coin opera news racks have the potential to decrease in public safety. Then how about the other news racks from other media forms in this hypothetical locality? Some of a conceived evil intent could be surmised to specifically address the disfavored position of a dispatch. Anyway, this expression was considered a content neutral, and the rule on a time, place, and manner regulations should apply. The ordinance is also invalid time, place, and manner restriction. To be valid, government regulations on speech in public places must be content neutral, narrowly tailored to serve a significant governmental interest, leave open alternative channels of communication. This rule has a great potential to be applied in many of Korean cases disputed in the Korean Constitutional Code. While, as discussed above, the ordinance is content neutral, it is not narrowly tailored to serve a significant governmental interest. There is no connection between the interest it seeks to serve and the means used to achieve it. there is no evidence that the banning coin-operated news racks promotes public safety. Finally, because the dispatch is free to dispute its newspaper through other means, the ordinance leaves open alternative channels of communication. However, because the ordinance is not narrow-tailored, it failed to suffice all the required preconditions developed by the court. Therefore, it is destined to be unconstitutional. Dispatch may raise an equal protection issue based on a 14th Amendment. Equal protection clause requires that the laws be applied equally to all. Dispatch will argue that by prohibiting only coin-operated news racks while allowing news racks for a free publications, the ordinance discriminates arbitrarily against owners of a coin-operated news racks. Classifications which do not involve race or gender must meet a rational basis test and will be upheld unless there be no rational relationship to any conceivable legitimate governmental interest. And your answer might be further on the equal protection issues. And for the time restraint normally imposed on the exam, the pages of your answer would be addressed 3 or 4 pages. On the page classed A4. Okay, now I could be easy to assume that you could have some ideas on the United States Constitution. As I've said, it is not exhaustive in scope or the degree of a class discussions, but I hope you can obtain the basics of a United States Constitution. In the next class, we advance to the next sector of U.S. contract laws. Okay? Have a pleasant trip, a national holiday. See you in the next class.